Hey everybody, welcome back to Guns and Gadgets. Thanks for watching. Yesterday, February 4th, the U.S. Court of Appeals 4th Circuit rendered a decision in a major case as it regards to the Second Amendment. What was being challenged was a 2013 law put forth by the state of Maryland, which absolutely banned any AR-15 or assault-style weapon or any magazine that would hold more than 10 rounds. That case was known as Colby versus Hogan. And what came down as a decision was several good things, actually, for gun people. A, you can't just ban the AR-15 or any assault-style weapon if it is something that is legally possessed, legally used, and the majority of the people own it, which is the case of the AR-15. It's the most popular center-fired rifle style in the United States of America. They also said that banning an entire class of weapon, such as the AR-15, was a violation of the U.S. Constitution. It also referred to past case law where it's illegal to ban a specific piece of a firearm. For instance, banning a firing pin of a firearm, which, you could have the whole gun except you can't have the firing pin, because banning that one piece would make that gun no longer usable. That's illegal. The big thing is when they addressed the 10-round magazine issue. First off, the Attorney General of Maryland argued the point that they could ban these magazines because the Second Amendment didn't protect magazines as they are not firearms. I want to read you the quote from this case as it regards to the standard capacity magazines that all the liberals want to call high capacity magazines. And what it says is, magazines holding more than 10 rounds are common and standard. There are more than 75 million of them in the United States, and indeed most pistols are manufactured with magazines holding 10 to 17 rounds. In fact, virtually every federal court to have addressed this question has found that magazines over 10 rounds are in common use, and thus are covered by the Second Amendment. Folks, that is absolutely huge. There are many states that ban anything more than 10 rounds. My state included, the People's Republic of Massachusetts, the big nanny state. So now this sets federal case law. That is beneficial because if there's a case right now in Massachusetts that is bickering over the magazine limit, they now can refer to the Fourth Circuit Court of Appeals decision as it pertains to high-capacity magazines, saying that a ban on that is illegal. Now, the Attorney General of Maryland is, of course, going to try to appeal this en banc, which means to the Supreme Court, the U.S. Supreme Court. And if they go off of their past history for the last 15 or 20 cases presented to them as it pertains to the Second Amendment, they're not going to hear it. They're just going to leave it to the decision of the lower courts. So that is going to be big, because now a lot of cases can appeal, or a lot of cases can start. Hint, hint, if there's any constitutional lawyers out there that want to make a name for themselves, start suing the states for their ban on high-capacity magazines, because now there is a case that is now precedent. It's the leading standard. They can just refer to that case, so it should follow suit across the country as well. That's how case law works. For instance, the quote that's used, it's the government's burden to establish that a certain firearm falls outside of the scope of the Second Amendment, and there hasn't been one person to do that yet. Now, this decision came down 2-1, and the one dissenting judge basically implied that this decision would put the court in liability's way for further mass shootings down the road, to which the Chief Justice destroyed that. And I'll read you this quote. First off, his name is Chief Judge Traxler, Traxler, and he says this regarding the dissenting judge. Our distinguished dissenting colleague asserts that we have imprudently and unnecessarily broken with our sister courts of appeal, and infers that we will bear some responsibility for future mass shootings. In our view, inferences of this nature have no place in judicial opinions, and we will not respond beyond noting this. So what he's saying is, take your liberal political correctness and shove it up your ass, and that's awesome, because usually judges don't do that. They typically are very, very cordial to each other as far as dissenting opinions go. He goes on to say, The meaning of the Constitution does not depend on a popular vote of the circuits and is neither improper nor imprudent for us to disagree with the other circuits addressing this issue. We are not a rubber stamp. We require strict scrutiny here, not because it aligns with our personal policy preferences, but because we believe it is compelled by the law set out in Heller and Chester, which is another case law set up as it pertains to the Second Amendment. So that is huge. And what's even bigger about that, if you want to get into the politics and the appointment of judges, Chief Judge Traxler was appointed in 1998 by Bill Clinton. So he was appointed by a Democrat, and he went against, the grain as far as the gun control. And the dissenting judge, Judge King, was also appointed by Clinton. So now you got two Clinton people straddling the line. One's actually, pushing the Constitution, and the other one is pushing the party agenda. And the second judge who went in favor of Chief Justice was Judge Agee, or Agee, A-G-E-E, who was appointed in 2008 by George Bush. So there you go. Major case as it pertains to the Second Amendment. Please share this information. I guarantee you're not going to hear this like at the Democrat debate or anything like that. So please share this information. It's huge information as it pertains to the protection of our rights under the Second Amendment and our ability to defend ourselves, and high-capacity magazines. So thank you for watching. I appreciate your time. Please, like I said, like and share this. Subscribe if you haven't. I have all these new breaking news updates as they come, and I'd love to have you. Until then, take care.